Hi guys, so it seems like I had technical difficulties and my live video apparently didn't record the entire session, so I'm gonna have to do this one more time. I apologize for those who waited for me at 7 o'clock, but apparently we will be doing it again. So welcome back. Houston immigration attorney Pegah Rahgozar. Welcome back for another episode of Wednesday Wisdom with Pegah. A little bit about the Rahgozar law firm. Our principal office is in Houston, Texas, but we do take cases from all across the U.S. and outside the U.S. advising on U.S. immigration laws. Our office phone number is 832-792-3636, and you can learn more about this topic as well as other topics and more about me on our website at www.rahgozarlaw.com. Today's topic is about expedited removal. But before I dive in, as usual, I'd like to inform you that any information discussed in today's video is for informational purposes only and should not be construed as legal advice. Because every case is different and immigration is a fact-intensive area of the law, be sure to seek proper legal advice from an experienced immigration attorney before filing any sort of application with immigration. So I'd like to give a few shout outs to the LGBT community on celebrating the month of June, also known as Pride Month, and also wish an Eid Mubarak to all the Muslims across the world who are celebrating the end of the holy month of Ramadan. Some of the latest news in the immigration world: as of yesterday, Tuesday, the House of Representatives passed the Dream and Promise Act, which would provide a path to citizenship for more than 2.5 million undocumented individuals who are facing deportation. The concern, however, is whether this bill will actually pass in the Republican-led Senate. So stay tuned to see what the outcome of the bill is and whether it will pass into law. Also, the State Department is now requiring all U.S. visa applicants to share their social media accounts that they've had for the past 5 years. This can definitely hurt a visa applicant if they fail to disclose, or if they lie about having social media accounts, or if the State Department finds any damaging information on those social media accounts. Some crazy things happening in Central America. President Trump is working with the Guatemalan president to help halt migration. The migrant caravan that is trekking through Central America, through Mexico, and into the U.S. Basically, President Trump has sent DHS agents and investigators down to the Guatemala and Mexican border to help with the migrant situation down there. Also, protesters have set fire to the door of the U.S. Embassy in Honduras just a few days ago. So just some crazy things happening in Central America and just in general in the immigrant community. So on to our topic for today, expedited removal. Expedited removal is the process by which a non-U.S. citizen can be denied entry and physically removed from the U.S. at the port of entry upon seeking admission to the United States. Orders of expedited removal are issued by U.S. Customs and Border Protection, also known as CBP, and these officials issue these orders at the port of entry, either land, air, or sea. So CBP officers can summarily order the removal of nearly any foreign national who arrives at the border without proper documentation. Additionally, undocumented immigrants who have been in the U.S. 14 days or less and entered without inspection are also subject to expedited removal if they're encountered with immigration officials within 100 miles of the U.S. border with either Mexico or Canada. The expedited removal process can only be used in certain situations by CBP officers when they've determined that the individual is inadmissible for one or more than one of the following reasons. One, fraud or misrepresentation. Second reason could be falsely claiming U.S. citizenship. If you're not in possession of a valid, unexpired immigrant visa or other entry document. A non-immigrant who is not in possession of a passport valid for a minimum of 6 months from the date of the expiration of their initial period of stay, or a non-immigrant who's not in possession of a valid non-immigrant visa or border crossing card at the time of their application for admission. Most expedited orders that we see in our office tend to be either based on fraud or misrepresentation charges, or for someone who's not holding a valid visa or entry document. Some common cases of this is when CBP officers ask the non-immigrant a series of questions that leads to finding of past violations of their visas. And we see this commonly with those who enter on a tourist visa and actually work on those visas. And through the line of questioning, CBP finds out about that and then expels you from the U.S. through the order of expedited removal. Individuals facing expedited removal do not have a right to an attorney, and they do not have a right to have a hearing before an immigration judge. CBP officials at the U.S. Port of Entry conduct these processes completely and exclusively. The process is usually completed within a matter of hours while you remain in the custody of them. The CBP officers will interview the individual, they process paperwork, take photos and fingerprints, and then they'll send the individual back. If they enter through the land entry from either Mexico or Canada, then they'll be shipped that way back. They'll be sent back, through Mexico or Canada. If you enter through the airport, then you'll be sent back on the next flight to your home country. They will give the individual a copy of their paperwork. The paperwork usually entails Form I-860, which states the notice and order of expedited removal. Also Form I-296, the notice to alien removed / departure verification, and Form I-867A, the record of sworn statement and proceedings. And that record is usually the line of questioning that CBP has asked you and your responses to those statements, to those questions. If you're someone you know has been subject to an order of expedited removal and they would like to know what the options are to return to the U.S., then please contact our office at 832-792-3636. Make an appointment and we can discuss your case. Which individuals are not subject to expedited removal? By law, expedited removal may not be applied to certain individuals such as U.S. citizens and lawful permanent residents or green card holders. Also, those who are not subject or should not be subject to orders of expedited removal are refugees, asylees, or asylum seekers. And these are basically people who fear returning to their home country or who indicate that they'd like to apply for asylum. So if someone is subject to an expedited removal, but they claim fear of return to their home country, then the officer can detain you, parole you in, and then allow you to go through the credible fear or reasonable fear interview process with the asylum office to see if you have a claim for asylum. Many times, though, these individuals will continue to remain in detention while they await hearings and interviews with the asylum office, and that could take weeks or months depending on how backlogged the asylum office is. What are some of the consequences of getting an expedited removal? Well, expedited removal carries a 5-year ban to re-entering the U.S. That means the individual subject to the order of removal cannot re-enter the U.S. for a minimum of 5 years from the date of the expedited removal order, unless they apply for and are granted permission to reapply for admission to the U.S., and that's usually through a waiver. If you have multiple illegal entries or deported and illegally enter, then you'll be subject to other forms of bars that may be a lot longer or even permanent than the 5-year ban. Depending on the reason for your removal, what type of visa you're applying for, within that time frame you're subject to the bar, then you'll need to obtain a waiver before you can get a visa. And you'll have to go through the process outside of the U.S. until your case is approved and you're allowed back into the U.S. By first obtaining the waiver and then the visa through the consulate, and then you can enter the U.S. Can the order of expedited removal be appealed? Well, the short answer is no. So orders of expedited removal are not reviewable by a judge or a court. There is no appeals process for such orders. However, if you feel that you were given an order of expedited removal in error, then you do have a chance to request supervisory review of that order. And if they find that there was a clear error on their part, then they could allow you to come back in. If you or someone you know has received a 5-year or 10-year ban and they want to apply for a waiver so they can come back to the U.S., then please contact our office at 832-792-3636 and make an appointment to discuss your case. So Mr. Benjamin actually had asked a question on the other live video I was on that I thought was recording, but apparently it was not. So he had asked if his sponsoring wife, who's also the sponsor on the affidavit of support, who's subject to disability, whether he needs to provide documentation from the Social Security Administration regarding her disability. But he also has a joint sponsor. So not necessarily unless they're requesting it, at which point you could probably take it to the interview if an interview has been scheduled. But generally, if you have a joint sponsor, then the joint sponsor has to meet the income requirements. So you should be good to go. We also had somebody else that had asked about wanting to invite their friend from Morocco to come visit and what the process is. Well, basically your friend could just apply outside the U.S. through the U.S. Consulate for a tourist visa or a visitor visa, either a B1 or a B2 or a combo B1, B2. They would apply through the Department of State on the form DS-160, pay the non-immigrant visa fee, schedule an interview, and attend the interview. As the individual trying to invite their friend to the U.S., they definitely can provide a letter that they'd like to request this person to visit, along with the affidavit of support on form I-134. But however, it's not part of the eligibility requirements to obtain a tourist visa, so the consular officer may not even look at those documentation. They go strictly based on the visa applicant, their ties to their home country, if they've ever traveled outside the country and returned, you know, things like age factors in, and so on and so forth. So, or if they've had any past violations, if they've come to the U.S., been deported before, or worked without authorization, so on and so forth. So it's really a quick little interview with the visa applicant for them to establish whether they want to grant or refuse the visa. But like I said, sometimes individuals send letters or affidavit of support, but it's not really a criteria to obtain a tourist visa. So if you guys have any questions related to this topic or any other topics, then please contact our office at 832-792-3636. Make an appointment so we can discuss your case. That concludes another episode of Wednesday Wisdom with Pegah. Thank you guys, and I'll see you guys next time for another episode of Wednesday Wisdom. Hope you guys have a wonderful night. Bye-bye.